Well, good afternoon and good morning, everyone, and welcome to Thrive, a monthly webinar series brought to you by ARCpoint Labs, your single source employer solutions provider, helping business leaders create compliant, safe, and healthy workplaces that thrive. Today's topic, reducing legal risk in the workplace, real legal lessons involving recruiting, hiring, and performance appraisals. My name is Ryan West, your host and Thrive specialist, and very pleased to share the virtual floor today with a highly experienced attorney, Thom Cope. Before Tom takes the virtual stage, however, a few brief but important announcements. First, ARCpoint's Thrive webinar series is held the third Thursday of every month. They're free, accredited, and you can register for our Q2 series lineup today. So that's May and June webinars. Today's topic is grounded in ARCpoint's background screening and pre-employment post-offer drug testing solutions. And next month, Mr. Cope is going to present once again, but his focus will be real legal lessons involving corrective action, termination, and drug and alcohol related issues. A critically important and timely topic in today's age that you do not want to miss. The links to both of the May and June webinars are now in the chat. You can also register for the June Thrive webinar presented by attorney Jenna Shives, who will conclude our Reducing Legal Risk in the Workplace series by sharing her expert insights on how to build and implement an employee handbook that actually works. Also greatly looking forward to that webinar. Second announcement, each Thriving Thursday webinar features a new speaker and or new topic that is one, aligned with ARCpoint's suite of employer solutions, and two, aligned with your voice, right? Content and or speakers that you have requested for this monthly series. So keep sharing your voice. Once today's webinar concludes, there will be a survey. It's quick, it's easy, and it gives your voice an anonymous platform to influence the type of content that you consume. All right, so let ARCpoint not just be your single source service provider, but also a key education provider as well. And lastly, I want to quickly address the frequently asked questions that we get at the beginning and end of our Thrive webinars, such as, is this training being recorded? How do I access the recording? Will I receive a copy of today's slide deck? Yes, you will. Are CEs being offered? How will I get them? And when will I receive my certificate of attendance? Answers to all those questions are now in the chat. So go to the chat, review that info. Also say hello. Let us know where you're logging in from. If you have questions for our presenter, please use the Q&A function and use the chat for everything else. Again, if you have a question for Tom, and I know you're going to have questions, please use the Q&A function so that he can answer it towards the end of today's webinar. And use the chat for sharing color commentary, sharing your own personal stories relevant to today's topic. It is now my pleasure to introduce today's presenter, a highly experienced and highly accomplished attorney, Thom Cope. Tom has practiced labor and employment law for more than 53 years, so a little bit of experience. He has also served as a judge in the area of public employment law, has been recognized in Best Lawyers in America, Arizona's Finest Lawyers, and Southwest Super Lawyers. And in 2021, Tom received the Rogers Hayden Award for Outstanding Achievement from the Labor and Employment section of the Arizona State Bar. Tom is a partner with Mesh, Clark, and Rothschild and draws on decades of employment law practice to help employers avoid preventable workplace mistakes before they escalate into legal disputes. With that, welcome, Tom. So glad to have you with us today. The floor is yours.
Thank you so much, Ryan. I was thinking about this presentation today, and when I started practicing law in 1972, you realize there were no computers, there were no cell phones. People got together personally when they had a seminar like this. They'd be in a big room, and people would talk through a microphone. Now, with the modern technology, we have over 300 people registered, and who knows how many people are actually attending. I think it's totally awesome. So let me start you off with a little bit of philosophy. In my book, How Not to Be a Stupid Manager, I put this in there. Nobody gets up by putting other people down. In other words, let's treat everybody like they want to be treated, not like how you think they should be treated, but how they want to be treated. And then I think to myself, if you're a manager or a supervisor or an HR professional, think about how you manage people. You actually lead people. You do not manage people. You manage processes. And so with that, let's see what we can figure out for the rest of the day. So in this session, we're going to talk about recruiting, hiring, and conducting performance appraisals. Next month, I'll talk about corrective action and firing people and see how we can do that legally. So the interesting thing about recruiting is you have to know something first. So one thing we always want to understand is that even though we're not going to talk about all the legal ramifications in today's world, we do need to understand what the genesis of all this is about. And that is 1964. Many of you on this call or on this Zoom were not born in 1964. I was actually a junior in high school in 1964. And I will tell you that was the law called the Civil Rights Act of 1964, which said to the employer, you may not discriminate on the basis of race, color, creed, sex, and religion. And of course, as we all know now, we have the Americans with Disabilities Act, we have the Genetic Act, we have Equal Pay Act, we have the Age Discrimination Act. We have all different laws now, but we have all these people that are now in what's called a protected class. And a protected class is anything that is protected by the statutes. And so there's just a list of some of the areas of protected classes that we talk about. And when we talk about hiring and recruiting, and we talk about performance evaluations, we have to always look at this as a background. That always behind us, we're looking at, are we discriminating against individuals based on their protected status? And our performance evaluations, our hiring processes, our recruiting processes discriminating against people in protected classes. Those are the kinds of things we're going to talk about, but we're not going to talk about the legal aspect. We're going to talk more about practical, which I think in some way, if you keep in mind the legal framework that we're dealing with, then we can take it to the what are we talking about on an everyday basis. So we're going to explore a couple questions. Is choking your employee's subordinate employee okay? When is a not a not? When is taking pictures of your employees not okay? Is it okay to badmouth former employees? And finally, is it okay to puff up a performance evaluation to motivate an employee? During the course of this session, we will answer those questions for you. But let's talk about this. How many people in this room, Zoom room, are doing hiring and firing, right? So, but before you recruit for a job, before you actually start interviewing, what do you need to know before you do anything to fill a position? And if you all said, what is the job, you would be right. Just remember, you cannot hire someone if you don't know what the job is. And that doesn't mean just the job description either. We'll talk about a little bit about what goes into hiring a person, because it's not just the resume. But how do you get people? Are you all doing the Indeed or the internal announcements? Are you doing any of that? Are you doing word of mouth? Are you doing internet, newspapers, trade journals? Do you state equal opportunity employer? So the question I have for you is, do you go to Indeed or ZipRecruiter or people like that? Do you actually tell people in your organization that there's an opening for which they can apply if they're qualified? Because a lot of times when I have these failure to hire lawsuits that I defend, and I do defend about, I'd say 90% of my caseload is the employer defense, and about 10% is representing employees against employers. I have a very robust sexual harassment practice where I represent women people that were being sexually harassed in the workplace. And I also have a very robust defense practice where we defend lawsuits against our employers who um, are alleged to have discriminated against employees. But what do you do for recruiting? Do you actually tell people that you're an equal opportunity employer? You know, in today's world, the EEOC has talked about they're actually advertising for Caucasian males to file discrimination complaints against employers for discrimination because they've been passed over for promotion or for hiring in favor of a protected class. Well, so now you have to define, you know, way back long time ago, there was something called reverse discrimination, where people that were Caucasian were arguing that they were discriminated against in favor of somebody in a protected class. Well, now the EEOC is actually advertising for people on their website to file charges against employers based on this reverse discrimination issue. So be careful when you do your hiring that you treat everyone equally and make sure that everybody is treated the same with the questions that are being asked and things of that nature. So before your recruitment ad goes out, and most people are now doing online recruiting. Very few people are advertising in the newspaper. Very few people are advertising in trade journals. But every once in a while, you get that, so you have to be careful. But determine what are the job-related requirements, right? What are the characteristics that match up with essential functions? So let's assume for a moment that you have a job that, like a lawyer, you want to hire a lawyer. It's not a job that is team oriented. It's more individually driven. We want to have people in our law firm that are self-motivated, that go out and get clients, work with clients. We may have a paralegal or somebody like that that may help them, or a legal assistant, but we want self-starters. So when I'm recruiting for a new lawyer, I want to find out if that person's a self-starter. Same thing in your organization. Are you part of a team? Is this person part of an actuarial team? Are they part of a human resource team? Are they part of a team that does, you know, a research project, or is oriented as opposed to individual projects? These are the kinds of things you need to find out and know, because if you don't, you're going to hire the wrong person. If you hire the wrong person, literally that's on you. I always figure if you have to terminate a person within the first 30 to 60 days, you've done a really poor job of hiring that person, because literally you've not given them the opportunity to be successful because you haven't hired the right person in the right job. Every job, as far as I'm concerned, should have a listing of the essential functions. And the essential functions is a legal phrase put into the Americans with Disabilities Act. So you don't want to just say job characteristics or job functions. It's essential functions is how you should list your jobs. And for that, you really need to drill down on what is the job. What are we talking about? Are we talking about somebody that has to lift 50 pounds? I have a client that is a nonprofit. They provide pet food for homeless people and for organizations that, like Humane Society, and people and organizations that provide pets and adopt pets out for that are at risk. And one of the requirements of that job is to have a person that can lift 50 pounds of animal food for their clients. And so if you can't lift 50 pounds, you cannot do that job, because there are lots and lots of bags of dog food that weigh 50 pounds. So as an example, you want to make sure that for your job, that you have every position and every essential function listed so that you can hire properly for that position. Remember also that the resume is an advertising piece. So if you're hiring for a professional position, don't use the resume as a guide to interview with. Your guide should be the essential function of the job. Every interviewer should know exactly what that job entails. And so some companies are big enough where they have just a uh, internal screeners and advertise and interviewers. Others companies have the manager or the supervisor do the interviewing for that job. If you have an outside person like a human resource relations person doing the interviewing, make sure that person understands and knows what the job is, what a job entails. Every interviewer should know what it takes for the applicant to be successful. So what's really important is to find out what are the top essential functions of the job. Do you have to have lifting ability? Do you have to have computer skills? Do you have to have legal ability or legal training? Whatever the job is going to be, you need to know that. It's very important because I find so many times when I defend cases on failure to hire is that people just don't seem to understand that they're hiring for a particular job and they don't want just a warm body that can speak and breathe. You want somebody that can actually perform the function of the job. And what happens in a lot of cases that I've had is that people get screened out because they're not asked the right questions. And then you hire somebody and let's just say a non-protected class person, and then a person that's of age of 60, let's say 60 years old, comes in and says, well, I have more experience. I've done this job more often than the person you hired who's just right out of high school, and you just hired somebody that's unqualified, and I'm more qualified because I've been doing this a long time. So you want to be sure that you don't take into account any of the protected factors, age, sex, race, color, creed, national origin, etc., in your hiring processes. There is something called a bona fide occupational qualification, BFOQ. And what that means is if you need to hire someone that must be able to lift 50 pounds, you can not hire, you can refuse to hire somebody who doesn't meet that qualification. Why? Because that job requirement of lifting 50 pounds is a bona fide occupational qualification. Now, the big question is that true? That's going to be the legal question. Is it actually true that that person has to lift 50 pounds? And if so, then you're okay. But if you can have a job, if that job also entails lifting 20 pounds or 10 pounds, and you can have someone else do the 50-pound lifting, is that something that you might need to accommodate somebody with a disability? So these are kinds of questions that you ask yourself and find out, can I hire, can I hire a person that can't lift 50 pounds, even though my job requirement is 50 pounds? So these are things you need to think about, particularly when you have somebody that comes in with a disability and says, my back hurts, I can only lift 20 pounds. The question for you is, are you able to do an accommodation for that person even before they're hired? And my answer to that question is going to be probably not, because the job requirement really is a bona fide occupational qualification to lift 50 pounds. I've been over to my client's warehouse, and it's absolutely imperative. I mean, if I don't know how many of you have pets or big dogs where you buy a bag of dog food that weighs 50 pounds. We have a couple of dogs. The biggest bag of food I have to lift is 10 pounds. So, because we have a couple of smaller dogs, but that's just an example. Now, when you are interviewing, remember one thing, all questions have to be job related. So as an example, let's assume for a moment there's night work. People have to work at night, people have to work on the weekends, people have to travel. So you ask a man, can you um, can you do this job? And the person says, sure, I can do all that. And then you ask a woman, does your husband mind if you travel? Does your husband mind if you work late? Do you have kids that are going to keep you from working late? Why would you ask those questions? Because are they job related? No, they're not job related. What's job related is the one question is, can you travel? Can you work at night? Can you work on weekends? If the answer is yes, and of course, you ask those questions to everybody. You don't just ask them to women or people of color or people in protected classes. You ask that question of everybody. And what happens then is if that person says yes, that's the end of the inquiry. I have so many clients that want to go behind the scenes and say, now I understand you told me now that you have two kids at home that are, 3 and 5. Are you sure you can work at night? Once a person tells you they can work at night, you cannot go behind the scenes and start grilling them about something that has nothing to do with the job. The other thing that I find in Arizona, and most of the states that are represented on this call are probably at-will states. So there's something called the at-will rule, means you can fire somebody at will, and that person may quit at will, and there's no guarantee of employment. Now in California, of course, things are a lot more employee-centric, and you have to have just cause for termination and all that. But in most cases where you're in at-will state, you do never, ever, ever want to promise a person they have a job for life or anything close to that. What I find people saying is, as long as you keep doing a good job, you're going to have a job here forever. That's not something you want to say, because if you're in an at-will state, you do not want to give yourself or give the employee any ammunition to keep them from getting fired if they are not doing their job. So if you're going to do a proper job of interviewing, let's remember, you need to know the necessary skills, behaviors, motivation, interest, drive, and energy. So you may say to yourself, well, that's pretty subjective. Well, yeah, it is very subjective, but it's also part of the job. If you have a person that just is looking for a job and is applying because they're on unemployment and they have to just fulfill the requirement, that may not be somebody you're interested in. What you want is somebody that's motivated to work for you, and that's what's important. And so I think it's very important that everybody understands that when it comes right down to it, people are just looking for jobs right now. But it's your job as an interviewer or as a hiring official to make sure that you hire the right person for your company. And you would know what your company culture is. Is it a collaborative culture? Is it a culture where people are more independent? Like at ARCpoint here in Tucson, we have a lot of people that are very good self-starters. They work hard, and they don't need to be told what to do every single day. Do you have a job where a person has to be micromanaged every day? Then you better hire a person that's okay with being micromanaged. If you want an independent thinker, then you better hire an independent thinker. Just remember what your corporate culture is. So I always think there are at least three things during an interview that are important. The one thing, of course, is you have to assess the applicant. The second thing is you have to describe the job to the applicant, because you know what? What happens if you describe the job inaccurately and all of a sudden the person says, hey, you know what? You didn't tell me that this was a part of the job. If you would have told me, I'm not into this, I don't want to do this. So always describe the job to the applicant in detail. But what a lot of people don't understand is that you have to also create goodwill for your company. It's important because why? Let's think about this. You have a job applicant. Let's assume you interview 4 people or 3 people. The first person you want says, nope, sorry, I took a job with another company, or this job's really not for me. If you come off as a jerk to the employee applicant, you're not going to get any people. And what's going to happen is people are going to say, no, I don't want to work for that company. That person's such a jerk that interviewed me. I have nothing good to say about the company. So I always say to people, look, when you interview people, create goodwill. Create goodwill for your company. Create goodwill for yourself and your department. And to do that, you really have to care. You should not be mailing in your interviewing skills, right? You got to care. You got to be alert. You got to be perceptive. Got to be free from prejudice, and you have to be even-tempered. So I think it's really important that people don't understand that interviewing is a skill. And one things that makes skills important, I mean, we were just talking with Ryan and Kirsty the other day, today about their kids' skills and what they're doing. It's important that you care about hiring. Hiring is what's probably one of the more important things you can do in your job because that's what's going to keep you from getting sued. Number one, if you do it properly, it's also going to get you a successful company to make sure that you have performing employees and not a bunch of guys that just sit around collecting paychecks. So let's see if we can answer a couple questions. Just remember that bad hiring makes for bad decisions. So is it okay to choke your employee? That's a good question, right? So I represent a company where let's say the manager had told his employee that he was not going to get a raise. He had promised the employee a raise after 6 months during the hiring process. So during the hiring, the man said, you come to work for us, here's your rate of pay for now, but in 6 months, we're going to give you a raise. 6 months comes along, the employee goes to the supervisor. The supervisor says, nope, you're not getting a raise. Yeah, but you promised me a raise. Nope, you're not getting a raise. So the employee goes to the supervisor's boss and says, hey, supervisor's boss, Johnny told me I could get a raise in 6 months, but he won't give me a raise. Well, the supervisor, his boss says, nope, you're not getting a raise unless Johnny says it's okay. Come to find out, the boss talks to the supervisor, and the supervisor gets so upset and so angry that he gets his employee in a headlock and chokes him in the parking lot and throws him to the ground. So we get this call saying, what do we do with our supervisor? Of course, the next thing you know, he's out the door for literally being stupid, which is why I titled my book, How Not to Be a Stupid Manager, because I have a lot of stupid manager examples like that. But what we didn't know is when we hired that supervisor that he had an anger problem and it was documented and it would have been come up on a background check. So that's one thing. So when is a knot not a knot? That's a good question, right? When is a knot not a knot? How about when it's a hangman's noose? Represented an individual, in this case, who is a black individual, African American, who every morning when he got to work at the job site around lunchtime, he would have a hangman's noose hanging off of his mirror. Now, so he says to his boss, hey, boss, I got this hangman's noose on my mirror every day and I don't know who's doing it. And what does the boss say? Don't worry about it, it's just a knot. Well, it's just not just a knot when a person of color has got a hangman's noose hanging off their mirror. We wound up suing the employer for discrimination based on race in that case and wound up with a really good settlement. What happened in that case was that they had hired a bunch of racist people working in the job site, and these were jobs where they were painting cell towers. So they would go up high on ladders and scaffolding and climbing up ladders and up on big big towers and painting them the gray color that you see when you happen to see a cell phone tower. And when the guy was up on top, they put this hangman's noose on his mirror. And so what we found out is that a couple of people that were doing it, after what we call a discovery, we actually had some background checks made on their employees, on the company's employees, and find out that they were terminated in other jobs. We took their depositions, and they were terminated from other jobs for racist behavior. So we're gonna talk about negligent hiring in a minute. So when should you not take pictures of your employees? Well, when they're in the bathroom. So I represented an employer that had a supervisor who went over and went in the stalls of the bathroom and took pictures of an employee over the top of the stall in the bathroom and then printed it out and put it on the bulletin board. And another case where a person took a picture of a coworker's behind her butt and posted that on a bulletin board. So these are the kind of stupid manager tricks that people do that you want to make sure that when you do your hiring, that you ferret out the people that, and you can do this with with legal questions. Find out whether or not these people have, are sexually harassing people or they're racially motivated, and that's the kind of thing that I always ask a lot of people. What do you think about this? What do you think about that? Because it's not illegal to ask questions about their philosophy in life, and I think sometimes you find out a lot more than or find out more than you need, but also sometimes you find out exactly what you need. So here's another one. When should you badmouth your former employee? How about never? I had to represent a company that the employee what the employee had done was to call the payroll company and give herself a raise without the employer knowing about it. I mean, literally doubled her pay by calling the payroll company. The employer found out about it when he was checking his payroll accounts and said, where did all this money go? So he winds up firing the employee. And then the next day, he tells everybody that would listen that the employee was stealing from him. And so he told a photocopy guy, he told the person that delivered the soda to his office, he told the elevator, the business building manager of his office building, running the elevator guy. I mean, he was telling everybody this person stole from him. Next thing you know, he gets sued for defamation. And then we spend $50,000 to defend a case that didn't need to be defended. That you just keep your mouth shut. When you terminate somebody, we'll talk about this next month, but when you terminate somebody, let's just let it go. There's no reason to badmouth your former employees. So if you look at all those questions, how many of those questions could have been answered by doing a proper background check, right? How many people could have been ferreted out? How could we have cleaned up or made sure our workplace was sanitary from people like that through a background check? And I would dare say a background check would be extremely important. Um, and it's not just people in a warehouse. It's not just engineers in the workplace. It's not just a legal assistant or a front desk clerk or a receptionist. It's pretty much everybody you could benefit from doing background checks on people. So that brings me to this. Lawsuits you should dread. Negligent hiring. We settled with that guy that got choked. Why did we settle with that guy that got choked? Because we didn't want to have to go to trial with a supervisor grabbing a guy around the neck. And the supervisor was about 250, 260 pounds, and the employee was about 150, 160 pounds. And this guy was literally choking and thrown to the ground. That's not the kind of case you're going to want to take to trial. So we would settle with that person, of course. And it's all part of your negligent hiring. Because had we done a background check, we would have found it. Well, had they done a background check, the company, they would have found out that he had an anger problem and might not have hired him at that point. The defamation lawsuit is also one that you want to dread because there's nothing. Truth is a defense, true, but why go through $50,000 or $100,000 worth of legal bills to prove that your employee stole from you when in fact, if you just keep your mouth shut, you don't have to worry about any of that. Oops, hang on. There we go. Hit the wrong button. All right, so let's talk about performance evaluations. I have to be mindful of the time because we have questions that we want to get to as well. But interestingly enough, when you're doing a performance review, there are three things that happen. You have a personal bias, and there's nobody on this call. I don't care if there's 100 people on the call or 300 people on the call. Everybody has a personal bias of something, right? Everybody has a personal bias. The other fact, and so what I'm telling you is stay away from your personal biases when you're interviewing or doing performance evaluations. There's also something called a constant error factor. The constant error factor is when when a person does the same mistake over and over and over, but then does everything else fine, and you downgrade their evaluation because of the one thing. Oh, you give them an overall bad evaluation as opposed to just a bad point on that one topic. Same thing with the halo effects, the other way around. It's where they do everything right in one area, 100% great, but aren't really very good in everything else. But you give them a higher mark than they should get because because you're giving them props for doing the good thing most of the time. Hang on just a second. Okay, here we go. All right. Most people want to talk about all kinds of different things during a performance evaluation. My goal for you is to have three major points. The other thing is, some people don't like to give copies of the evaluation to their employees, and I say to myself, why would you not want to do that? How many people that are in this session right now get a performance evaluation thrust in their hands and say, here's your evaluation. Let's sit down and talk about it. And you're trying to read it and figure out what's going on while the reviewer is talking about your performance, and you're not really getting it. The reviewer is not getting his or her point across. And so my thought was give it to them in advance, maybe give it to them an hour in advance, let them read it, let them think about it, and then discuss the topics that you want to talk about. One thing will tell you is if you don't have one good thing to say on an evaluation, my question is, why is that person still working for you? If you can't say one good thing on an evaluation, or that generally the entire evaluation is negative, why is that person still working for you? One of the things we'll discuss next month is when to fire people. And I will tell you that in my experience of 54 years, people don't get fired soon enough. And when you don't, you want to get rid of them, but you don't. You give them a second, third, fourth chance. And next thing you know, you got a discrimination case on your hands when you finally do decide to fire them. The one thing you also want to not do, of course, is to attack people personally. I'm not a real big fan of attacking people personally. This is a business discussion. When you say to an employee, you're the worst employee I've ever had, and your performance is so horrible that you're attacking the person personally as opposed to their performance, you're creating for yourself a very strong chance to be sued. So when you're concluding the interview, review your 3 points, restate some details, allow the employee to provide information, allow the employee to fill out the comment section if you haven't, and have the employee sign the form. Why do you want the employee to sign the form? Because they're going to tell you if there's a lawsuit of some kind. I never saw this form before in my life. Now, the one thing you want to also mention is that if the person won't sign the form, then you sign it and say, and given to the employee on such a date, refuse to sign, and then sign your name. So after we're done with all this, you got to check the progress. What's the point of having an evaluation if you don't check the progress of the employee? So here's the last question for you today, I think. Is it okay to puff up a performance review to motivate your employee to perform better? The short answer is no, and let me tell you why. I represented an employee that was about 62 years old, and he had been with the company for 17 years. Every single um, evaluation was walks on water. He just couldn't do anything wrong for 17 years. Gets a new supervisor. Supervisor comes in and talks about you're really a horrible employee, but I'm going to give you a good evaluation to motivate you to do better. So he gives him the evaluation, and then 2 weeks later, he fires him for poor performance. So I have him on the witness stand, and here's how the cross-examination went. So you are the supervisor for the company, yes. And you wrote this evaluation, yes. And it shows that he was a very good employee, yes. Well, why did you fire him 2 weeks later for poor performance? Well, I just I just gave him an evaluation to motivate him to do a better job, but it didn't work. So I said to him this. So are you lying today about your reason for firing, or were you lying on the company form? Realizing that a performance evaluation is a company document. And if you fudge it or somehow don't fill it out properly, you're actually lying on a company document. And we got that guy a very nice jury verdict. And I will tell you that you do not want to, in any way, shape, or form, make puff up in performance evaluations so to motivate employees. Just remember one thing: money does not motivate your employees. Recognition, being treated properly, and things of that nature will motivate your employees. So in this session, I'm going to wrap up, Ryan, for you, as you suggested. In this session, we've discussed different techniques of recruiting, hiring, performance evaluations. And I will save the last slide till we answer. Well, let me get you this slide first. Excuse me. I will not let someone walk through my mind with dirty feet, from Gandhi. What that basically means to me is that you're going to do the right thing for the right reasons, and you're not going to let anybody change your mind for doing the right thing for the right reasons. So I'm going to stop sharing my screen, and we're going to start answering some questions. Ryan, that's what you want me to do, correct?
Yes, sir. Tom, we have about 15 minutes for Q&A, which is good because we have about 14 to 15 questions.
Okay, I'm looking here to, am I going in the chat for the questions?
The Q&A, if you
Yeah.
see the Q&A button, you click on that, and then you can start right at the top with Melissa's question and work your way down.
If I found a Q of A question, I would do that. Oh, don't
Well, I'm
say.
happy to present them to you if you'd like.
Yeah, would you? Because right now, are there 16?
There's 16
Oh,
submissions, but I think about 14 are actual questions.
okay, here I go. All right, Melissa,
There
how
you
do
go.
you see risk emerge when employers vary drug screening practices by state, such as testing for marijuana in some states but not others? Well, that's a good question, but the answer is this. Look, every state has a different rule, right? Every state, and that's what you have to concentrate on. It doesn't, is if you're a multi-state employer, what you have to do is um, make sure that you're compliant with that state. You're not going to get, if you get sued in Nebraska, nobody's going to come after you and say, what are you doing in Arizona? Every state has its own rules. Like Arizona has a very specific drug testing statute. It also allows the employee um, to challenge the drug test. So, and employers have to follow certain rules and procedures, which, by the way, all your ARCpoint people know all about it in every state. So the next question is, what are the most common ways employers unintentionally create risk when classifying roles as exempt, especially when job duties and job descriptions don't fully align? Well, yeah, that's interesting, isn't it? Job duties and job descriptions don't fully align. How often does that happen? Like every day, right? So you create risks by hiring people and not telling what the job's about, right? That's the problem, is when you don't tell all the employees or tell the applicant exactly what's expected. Now, classifying roles as exempt versus non-exempt is really a big deal. That would be the subject of a whole seminar on the Fair Labor Standards Act. But you cannot just declare people as exempt employees and feel good about it, because not all jobs are exempt jobs under the Fair Labor Standards Act. You got professional, you got management, you got all kinds of different categories. But I think I would be remiss if I tried to explain all of that in the next 2 minutes under the Fair Labor Standards Act. But I think it's Melissa, you're making a good point that um, classifying roles as exempt when they're really non-exempt will get you in a lot of trouble with the Department of Labor. Okay, in situations where state laws don't explicitly prohibit credit checks, what risks do employers still face? How have you seen those decisions challenged? Well, credit checks are an interesting concept, right? Because um, what the only reason you would do a credit check is if there was an essential function of the job that made credit an important function of that job. So if you're in banking, for instance, you might want to do a credit check to see if that person has declared bankruptcy. But remember, um, under the law, you have to get permission. You have to get them to sign off on doing a credit check, right? And just remember that. From a legal risk perspective, how do you view employers conducting background checks prior to conditional offer? What patterns have we seen when that timing becomes problematic? Well, I haven't really seen a whole lot of background checks before a conditional offer, but I see a lot of background checks after conditional offer, which is to me the time when you do that, right? If you're conducting background checks prior, you better get authorization on the application. Make sure that the application is very clear that you're going to do a background check even before the offer is made. But otherwise, I would say, do your conditional offer and do it in conjunction with a background check after the conditional offer. Next question is essential requirement acceptable as essential function? I think that's okay. I mean, you can call it what you want as long. I like the word essential in there because that's what the ADA talks about. Essential requirements are acceptable versus essential functions. Sure, I'm okay with that. Wendell, how are you this morning? How does a company handle hostile, untrue Google reviews? Google chooses not to remove by disgruntled employee. That's a really great question. I have a lot of that. Okay, hi, Colleen. Um, I have a lot of that happening. People get fired, right? And then they go on Google and give the company horrible reviews. And what I tell my employer clients is this: ignore it, let it go. Don't engage with that employee. It gets worse, not better when you do that. Just let it go. Don't let them get under your skin. Just, I mean, can't tell you how many times, I can't tell you how many times that happens with employers here in Tucson that clearly want to take on the employee. I have a big employer with 2,000 employees, and they just fired somebody about 3 weeks ago, and they got a horrible Google review. And they're like, "What do I do with this, Tom?" I say, "Just ignore it, to let it go, because it really does. It really does eventually go away." How do you feel about background checks results showing offenses indicating nolle prosecuted, which I assume means nolle contendere? Should the employer weigh that in on the hiring decisions or not? So the real question is going to be if the criminal offense is job related, then it becomes relevant, and it would be something to weigh. The employer should weigh. If the criminal offense that they've pled nolo contendere or not guilty, it's basically a form of saying I'm not admitting it, I'm not denying it, and it's called nolo contendere, which I think probably is what you're talking about, nolo prosecuted. So if it's job related, then it's very important. If it's not job related, in other words, let's say banking, and they've had no contest to a theft provision, very relevant. If it's a warehouse job or a receptionist position, maybe it's not as relevant. Who knows? But that's the kind of thing where you'll have to weigh whether or not a no contest plea or noli contendere plea is somehow job related. I wouldn't badmouth an employee, but is it defamation if it's true or a fact? No, it's not defamation if it's true or a fact. In fact, that is the one and really only defense to defamation is that truth is a defense. The biggest problem is, do you want to spend 20, 50, 60, 70, $80,000 defending your company to prove something was actually true? And the answer is surely would be no. How would you find out if an anger issue of a candidate through a background check? Well, what I've found out in those kinds of situations is that a lot of times you get them from people have criminal backgrounds that show anger. They might have been terminated from a job because of anger issues, things of that nature. It's not always easy, don't get me wrong, to ferret out a person with anger issues, but sometimes it'll show up on a background check, sometimes it won't. And when it comes to a negligent hiring case, of course, if you can't find it, you don't know about it, you're not negligently hiring. It's when you could have known or should have known, that's when it's negligent hiring. How much time we have left, Ryan? Here, a
Got
few
about
minutes.
7 minutes left for questions.
Okay, got it. So Heather wants to know how is asking a potential employee about their philosophy about life staying within the guidelines of only asking questions specifically about the job. How is that worded to conform to job specific? Okay, so that's a great question, Heather. Thank you. The way I look at this is, look, I want to find out if you're the right candidate for this job. I want to find out if you have, um, if you're a person that discriminates against minorities. And there's nothing wrong with asking people job-related questions. It's all job-related when you're talking about. So how do you feel about, for instance, saying something like, how do you feel about people that complain about being discriminated against in the job place? And then you'll find out how they feel about that. How do you can ask them, how do you feel about what's going on in the world today? How do you feel about the fact that the EOC is asking um, males to file discrimination complaints? You can ask questions like that because why? It's very important that you hire people that are not going to discriminate against your employees if they're particularly in management roles. So I think that's more important, maybe perhaps in a management position or leadership role, but it's certainly, you don't want people to be sexually harassing their employees. You don't want people treating their employees differently because of their race or their protected status. So if you can ask questions about how do you feel about this or how do you feel about that, as long as it's job related to what you're talking about. I don't have any problem with that at all. Gretchen wants to know if you found evidence of anger issues in a background check and decide not to hire, isn't that discrimination too? Well, no, because frankly, there's no protected status. An anger issue person with anger issues is not in a protected status. I suppose down the road somebody could say, well, I have an anger issue and that's an American with Disabilities Act. I have a disability because I have an anger issue. Yeah, good luck proving that. But I would suggest that just having anger issues in a background check is okay to not hire that person because you don't want to put yourself at risk if of having a person, blow up. And I will tell you that in today's workplace, it's pretty crazy, right? People get fired and they bring a gun and they start shooting the place up, and that's what happens in a lot of employers. Lately, in the last 5 years, I've seen more of that than I care to even remember or think about. But it's not illegal to not hire to fail to hire somebody because of an anger issue. Um, is there anything preventing you from coming to work on time every day as scheduled? Yes, you can answer. You can certainly ask that question. Absolutely. Why? Because coming to work on time is absolutely a job essential function of the job, isn't it? When you think about it, if it isn't one of the main essential functions, it's pretty darn close to the main essential function of coming to work on day as scheduled. So you can absolutely answer that question, ask that question. So here's how you ask that question. Is there anything preventing you from coming to work on time every day as scheduled? And the answer is yes. Then you want to find out why. If the answer is no, then the inquiry is done. So good, that's good. Now, what about disciplining or terminating employees who commit unhygienic acts in employment restrooms? I don't have any problem with that. If you can prove it, get rid of them. No problem at all. I have no problem with that. It's not a protected class to be a slob in the bathroom. So if that's one of the problems, see you later. Bye. If an employee doesn't have a car but gets a ride to work and has been late a few times, can the employer make the employee get a car or be fired? Well, you can't make them get a car. I don't think you can make them buy a car, but you can certainly hold them to the fact that they're late and terminate them for tardiness, excessive tardiness or excessive absenteeism. Absolutely. but I don't think you can make them get a car. But you can certainly, because that's not job related, that's not job required. What's required is for them to come to work. That's what's required. As I said earlier, it's definitely an essential function of the job to come to work on time. Can you ask an interview about anger management issues, write-ups, or in previous roles? Sure. I don't have any problem with that. No problem at all. How can we legally prioritize construction experience in hiring while ensuring our criteria do not unintentionally discriminate against protected groups? If you stick to the essential functions of the job, if it's a construction position and you want and you have experience and you want experienced construction workers, then you can absolutely ask about what's your experience? How many, construction jobs have you held? What have you done on a construction site? Have you had leadership experience in construction? You can ask any of those job related questions anytime when you're trying to figure out what experience they have in your particular industry. All right, let's see. Tiffany says, current issue is employees accepting an offer, however, not showing up for orientation or not beginning servicing individuals. We are a home health care agency that dispatches support professionals for one-on-one support. Can we claw back our overhead payments of background checks, job materials, first check? If you can, so in Arizona, you have to get a written permission from the employee to deduct anything from their paycheck. So if you can get an upfront agreement from your employee, if you're in Arizona, and I can't speak to other states, I won't speak to other states. I'm admitted in California and Nebraska, but I don't want to commit to those two states even. But in Arizona, you can claw back those overhead expenses if you get permission from the employee upfront in writing that they will allow that. They will allow you to take the money out of their paycheck for any things of that nature. Can you question the nature of an arrest or only convictions? Well, again, I think that all depends on the type of job. In banking, I think you can you can inquire into the nature of the arrest. I'd lean toward asking about convictions more so because I think for that we know for sure that the person has been convicted and not just pled no contest or whatever. So I would try to stay away from arrests, but it all depends on if you're hiring for a CFO, a financial officer, it's probably a good idea to find out if they're arrested for, fraud or theft or something like that, but not convicted.
Tom,
Does
I'm
it?
going to have to unfortunately stop us right there.
Okay, thank you, Ryan.
You answered a tremendous number of questions. Thank you for that. And then you had also generously offered participants to reach out to you if they have follow-up. Is that correct?
So here is my thinking. What I would like to do is answer any questions that people may have. I'd be glad to do it for free, no charge. Just send me an email with the question, but in the subject line, put ARCpoint Labs seminar. You put that into the subject line, and I'll get back to you and answer any questions you have specifically to your organization, as long as you're not asking me to interpret your particular state law.
Wonderful. Tom, I just put your email in the chat for everyone to see, to copy and paste. And then also, again, make sure you enter ArcPoint Labs seminar in the subject line. Tom, thank you so very much. Such helpful and timely information. Please let Tom know what you thought about today's webinar by completing the post-webinar survey. The survey link will be posted in the chat very shortly. It will also be in a pop-up as long as you don't have a pop-up blocker once this webinar concludes. Also, let ArcPoint know how we can make your job easier, your business more compliant, and your workers happier, healthier, safer, more productive. This is what we do at ArcPoint. It's what we love to do. So keep the feedback rolling in. Next, if you're a credentialed HR professional, please look in the chat for your activity IDs. These will also be listed on your certificate of attendance, which will be emailed to all participants by end of day next Tuesday. As we talked about earlier, registration for May and June Thrive webinars is now open. If you'd like to register for one or both of them, you can do so by clicking on the individual links in the chat right now. And as always, if you have follow-up questions about today's topic, you're encouraged to reach out directly to your local ARCpoint Labs provider. As Thom mentioned earlier, many of our ARCpoint Labs franchisees are very well versed on background screening, pre-employment post-offer drug testing, and many other services. So reach out directly to them. And quite honestly, as Thom was discussing today, in today's business landscape, making informed hiring decisions is crucial. Right? A thorough and accurate background check combined with pre-employment post-offer drug testing is essential to ensure that new hires are not only qualified for the position, but also a good fit for your organization. And this is where ARCpoint Labs total reporting platform comes in. It's a comprehensive background check and drug testing service and an all-inclusive platform designed to make both processes easier, faster, and more reliable. For more information on those solutions and many others, check out arcpointlabs.com/employer-solutions. And again, reach out to your local ARCpoint Labs provider. All right, we have reached the top of the hour, covered a lot of ground in the past 60 minutes. Thom, any closing thoughts or final words of wisdom?
Well, Ryan, thank you. I want to thank you and ARCpoint Labs and Colleen Edwards here locally and Wendell Long locally for suggesting me to you. And I appreciate the opportunity. I will tell your participants and I will tell your clients that, look, hiring is a process and it's a kind of process you have to take seriously and look at that as your starting point to keep from being discriminated against, getting discrimination cases in the workplace. I look forward to any other questions you all might have. Like I said, again, it's going to be free of charge. Just give me a shout out to my email and I'm glad to help you out.
Awesome. On behalf of the entire ARCpoint team, a very special thank you once again to our presenter today, attorney Thom Cope, who we're going to see again next month. Don't miss that. And to everyone attending, our valued partners and loyal members of the ARCpoint network, it's an honor to serve you and to help you create compliant, safe, and healthy workplaces that thrive. We'll see you next month, everyone.